So I set a review hearing when you all were in front of me on July 21st of this year, in which I ordered Mr. Mercado to pay a lump sum of $4,000 by August 7th and $400 per month thereafter toward the arrearage. Does anybody have a payment record? Do we know if those payments were made?
I have one, Your Honor. I haven't uploaded it to Box, but I can tell you that he has made a total of $6,300 worth of payments that show up on the financial activity report since our last hearing in July.
And Ms. Sanchez, you agree with that?
Your Honor, I think we got our pay history too early. Mine cuts off beginning of October. But yes, at that point, I see that he had paid $5,936. So I think he's still coming up a bit short, considering that he was ordered to pay the $4,000 as well as continue with his child support and the arrears payment. Using Mr. Bledsoe's number. I initially got 1372, but using his number.
You got 1372 for what?
That he was missing.
All right, let's start with, okay. You all remind me, or I'll pull up the order. What's the current child support?
I think the current child support is 1,087, and then the medical is 167.
Mr. Bledsoe, do you agree?
I agree.
Well, 1,087 in current child support and 167 in medical support, right?
Yes.
So that's a total of 1,254 per month, correct?
Yes.
Plus, I ordered him to pay toward the arrearage $400 per month. Correct?
Yes.
Mr. Bledsoe, let's see your payment history.
Okay. So this is the portion since July. Is that good?
It's better, thank you. Okay, we were in court on July 21st. So on July 30th, I'm sorry, go up so I can see what the columns are again. Okay. Amount applied, amount due. Okay. 1,000, 2,000, 2,500, 3,500, 4,000, 5,000, 5,400, correct? Did I get that right?
Well, I'm still. Are you including the 500 and 200 that he paid on the 24th?
Oh, I'm not. No, I'm not. I'm sorry. Yeah. What do you? So what do we? Let's all look. So since for 5,400, 5,900, 6,100 between July 24th and the end of August. Do we all agree with that?
I would agree.
Sorry, I didn't catch that number.
I see it as 6,100 is what I'm adding it up to.
I got 6,300 the first time I did it, but let me run it again.
Well, we all need to get on the same page. Okay, do I agree that there's 7 payments of 500, 2 of 1,000? Right.
1, 2, 3, 4, 5, 6, 7. Yep.
2 payments of 1,000 is 2,000. A payment of 400 and a payment of 200.
Looks like your number's right. 6,100.
All right. And so what was paid in in October? Sorry. That was through August. What was paid in September? Only 700. What's been paid so far this month?
This is the most up-to-date record yet. I got this yesterday, so there haven't been any payments made in October. I understand that Ms. Herrera has authorized him to make a late payment this month.
Well, I ordered him to pay $4,000, a lump sum payment by the end of August. So he overpaid $2,100 in August, minus his current support in August of $1,654. I show that he made, so through August, if my numbers are right, he paid $6,100 from our hearing through August. I had ordered a $4,000 lump sum payment. He paid that. $6,100 minus $4,000 leaves $2,100. His monthly obligation is $1,654. I show that leaves that mean he paid extra $546. You know, I'm double checking my math. I don't trust myself. Anybody doing this math but me, or am I the only one that needs to do it?
I'm trying to track it.
Okay, here's what I have. Of the $2,100 above the $4,000 payment, he owed $1,654. That means he had overpaid $446 minus the $400 he owed toward the arrearage. He was paid up through August with an extra $46. In September, he's short again. In September, he should have paid $1,654 plus $400 on the arrearage. In September, he owed $2,054. He paid $700 and had 46 extra. So for September, he owes $1,308. He's behind in September. And we sit here on August 13th, and he owes another $2,054 before the end of this month. Ms. Sanchez, what is your client's position? I mean, he did what I told him to about the lump sum payment, but he's supposed to be keeping current on his other obligations.
Yes, Your Honor. And I mean, my client is appreciative of his efforts. She is concerned that once we're no longer in litigation, that he's going to stop making his payments. Since she hasn't received anything for October, I understand the month is not over yet, but so she wants to continue to receive the assistance. So I'm not sure if the court would be inclined to offer another compliance hearing or to continue to monitor him or.
Well, okay, so you think you've answered the question. I would do a compliance hearing. I could order him to jail today because he hadn't complied with my orders because he hadn't stayed current in September. So the question for your client is, do you want me to set another compliance hearing by the end of October to see if he can get current, or do you want me to have him start serving his sentence today?
Your Honor, I can ask her. Yuridia, Ms. Herrera, you heard what the judge just asked. Are you agreeable to set another compliance hearing, or are you requesting for Mr. Mercado to serve his sentence?
To send another claims.
Another hearing?
Yes.
All right. I'll set another hearing. Before I do, I want the paperwork done and then I guess I'm going to need it in person. Mr. Mercado, I'm going to have you come back by the end of the month. And if you can't comply with these orders, you're going to have to start serving your sentence. I appreciate you made the lump sum payment, but you are currently behind $1,308 for the month of September, plus you owe $2,054 for October. So you need to pay before the end of October $3,362, if my math is right, Mr. Bledsoe.
I agree.
All right. So let's set a hearing by the end of October, and we'll have the paperwork ready if you're not. I have a jury week that week, and I don't know how.
Judge,
Yes.
the best dates for you would be like November 8th or 9th.
All right, we're going to 4 o'clock on November the 8th in person. Mr. Mercado, I'm ordering you to appear in my courtroom in person on November 8th at 4 o'clock. You're going to appear in person because your ex-wife is being very generous in not having me throw you in jail today, but I will. I've sentenced you. And if you don't get current by then, be prepared to go, and you probably will get a work release, probably, so you can continue to work and make your payments. Do you understand?
You need to unmute.
No. All right. We are in recess again until November 8th at 4 p.m. in person in the 419th District Court room, which is on the 11th floor at the Civil and Family Courts facility located at 1700. This is the second time coming back. Let's do appearances for the record again, please.
Yes, Judge. Jalen Jackson on behalf of the movement, Ms. Grion.
Aubrey Morgan Lopez on behalf of the respondent, Mr. Vance.
Okay. So when we were last here on September 28th, my docket note said I told you should both be prepared to make legal arguments about your positions and about how long child support continued or will continue in light of the Massachusetts order and the guardianship in Virginia. And hopefully, Ms. Jackson, hopefully y'all have worked on a payment record that is all in one document.
Yes, Judge. I actually have 2 payment records. One for if the court agrees that there is an ongoing obligation, and a second one in case the court is inclined to take the position that there is not an ongoing obligation. I also did some further consultation with a Massachusetts attorney who is on standby just in case the court would like to hear from an attorney in Massachusetts about the child support laws in Massachusetts. Although she does not want to be on the record, she would only be comfortable speaking to both you, opposing counsel, and I in chambers. That is an option as well. Other than that, Judge, I am prepared to give my summation of the research I've done on Massachusetts law and why I believe the child support obligation is in fact ongoing.
All right. And Ms. Morgan Lopez, you're prepared to do the same?
Yes, Your Honor. I figured we would do that in closing. However, are we doing that now?
No, we can do that. Well, I guess the only other thing I need to get in the record are the payment records or the calculations that Ms. Jackson has prepared. So have you?
I've not even begun my case in chief.
Oh, you're right. All right. Well, let Ms. Jackson get those payment records in, and then I'll let you put on your evidence. Ms. Jackson, go ahead.
Thank you, Judge. I would offer into evidence. Can you see my screen?
Yes.
I would offer into evidence exhibit M14 that I've uploaded to the box, as well as M15 that I've uploaded to the box. M14 is the child support calculation that I've gathered from the tool instructed to be used by the court. And it states that the amount due is $111,409.39. And if the court hears argument and concedes that the amount stops at an earlier age and is not ongoing, I've calculated that the amount would be $85,113.59. Both calculations include the confirmed arrearage of $96,000, which is from the April 26, 2016 order. The only difference between the orders, the calculations is one is ongoing and one is not ongoing.
Ms. Morgan Lopez, do you have any objection as a demonstrative to these calculations?
Yes, Your Honor, I've only seen one calculation. And my understanding of that calculation was that it was the calculation that Ms. Jackson intended to present, which included ongoing child support obligations after 2019. And that number I thought was the 85,000. So the way that she just explained it, I didn't understand that way.
All right, let's pull them back up and go over them one at a time, Ms. Jackson.
Okay, and I did provide opposing counsel with a copy of both. Here is M14, which would be the amount of $111,000 remaining due. And this is starting at April 29th, 2016. I can scroll down, sorry. Starts at April 26th, well, the first payment was due April 29th, 2016. The order was April 26th. And then I will scroll down. The last obligation date that I have included is today, October 13th, 2023. The second document is M15. And this one is $85,113.59. You will see that this calculation also starts April 29th, 2016. And the last obligation that I've included on this document is March 5th, 2021. And this is because this is the date the child would have turned 23. And the reason I've done that is after my research on Massachusetts law, and I do have that statute for the court's aid if needed. But child support in Massachusetts stops no matter what, unless there is a disability at 23. And so I stopped the calculation at the child's 23rd birthday.
And I'm sorry, Your Honor, I did misspeak. She did provide that to me, the second document yesterday afternoon, and I didn't realize it was a different calculation. The only one that I had seen prior to that and was able to really go through was the one that said 85,000. But I'm sorry, I think I'm so confused as to what.
Okay, M15, she says that is the calculation, assuming child support stopped on March 5th, 21, when the child turned 21.
No, with the child 23, Judge.
23, sorry. M14 is a calculation, assuming child support is ongoing to date.
Correct.
Understood. So I received M15. That's the only document that I had. Well, it was my understanding was it was a version of M15 that I had received. And then I'd asked Ms. Jackson to make some corrections to that document. When I got it back, the number was the 85,000, and I assumed again that that's what she was proposing. But I understand both of them now. I don't have any objections to either one of them being admitted.
M14 and M15 are admitted.
Thank you, Judge.
All right. Anything else, Ms. Jackson, for your case in chief before I begin with Ms. Morgan Lopez and let her call her client?
Yes, Judge. I would like to call Ms. Grullon in regards to her efforts to provide information to Mr. Vance over the years. Thank you, Judge. Ms. Grullon, you guys were divorced in 2003, correct?
Yes.
And the last time we were here in court, Mr. Vance's attorneys suggested that you were supposed to reach out to Mr. Vance to provide him with things like your address and any contact information so that you could receive all the information that you were requesting. Is that correct?
Correct.
Okay. And can you tell the court what your experience has been generally in trying to get in contact with Mr. Vance?
I have, since our separation in 2000 and since the separation, divorce in 2003, I have made multiple modification requests to the last known address for Mr. Vance because he was not providing his address. I sent letters to the last known address that I would have. I emailed him with my address and phone number requesting that he submit those earning statements over the years. My attorney previously had requested that he provide the address, which he did not because he said it had sensitive information on it. I tried to reach out through family members of his because I had no contact information, who refused to provide his contact number or address, and he did not contact me through them. So
thank you, Ms. Clear. And so when you speak of family members, can you think of, well, do you know the name today of any family member that you have reached out to in order to provide your contact information to Mr. Vance?
Yes, his sister, Tishawn Willow or something is how she has it listed on Messenger.
Okay. And when you say Messenger, what app are you speaking of?
Facebook Messenger.
Okay, Judge, I'm going to share my screen so that I can offer Movements Exhibit M13, which is a screenshots of Ms. Gruillon's attempts to provide contact information to Mr. Vance's sister after her multiple failed attempts. And if there are no objections, I would ask that this be admitted into evidence.
I objected to hearsay, and then I objected to relevance as to some of the content of the text messages.
It is hearsay. But she's testified that she did it, so I'm not going to admit it. But her testimony is evidence.
Thank you, Judge. Not a problem. At this time, I pass the witness. Thank you, Ms. Gruillon.
Ms. Morgan-Lopez, do you have any questions for Ms. Gruillon?
Yes, Your Honor. Ms. Gruillon, you are aware that that Mr. Vance's child support obligation terminated in Massachusetts in 2019, correct?
No.
You're not aware that his obligation terminated in 2019?
Objection asked and answered.
Overruled.
No, I argue that I'm not aware because it wasn't my understanding that it was supposed to end 2019. She did have an ongoing disability. So that was why we're here still today. And I'm arguing for ongoing child support.
Okay. And in terms of the child support obligation in Massachusetts, when do you believe that ended?
Objection as to what my client believes as far as the end date of child support.
Well, she's not an expert, but she's here seeking child support. I'm going to allow the question, but I'm not going to take it as expert testimony. So you may answer.
And I would also object, Judge, as to cumulative. My client has already stated that she believes that the obligation is ongoing.
Overruled.
Sorry. Okay. Well, for our emancipation separation agreement, it did say that child support would be indefinite until she was emancipated. So that was my understanding, that I would continue to be able to seek child support for the remainder of her life unless she was emancipated, which she has not been.
Okay, and I can appreciate your understanding, but my question specifically is, do you have information or knowledge since 2019 that Mr. Vance's current child support obligation actually terminated in Massachusetts?
Yes.
Okay. When did you come across that information?
Well, it's not that okay. So this is the issue. I did not understand that it had terminated. I was told that I had to go to get a modification to continue to review her disability.
Objection as to non-responsive. Ms. Brian, I'm sorry.
Overruled. She may answer the question.
I was told, and it was my understanding, that at age 21, that it ended because there needed to be an additional evaluation of her disability. And not so much that it ended, but that they would need another notice from, I guess, the judge saying that it was supposed to continue. 2016, I understood that had been done. And, well, meaning the 2016 order, I thought, because it did not specify that anything had ended, that had been established. Massachusetts told me that they could not enforce anything further because he had been non-compliant to date. I would have to seek counsel elsewhere, which is why I'm basically had to get a Texas attorney, because they could not enforce any additional judgments. He had already not complied. The attorney literally told me that we'd be in the same place if I came back to try to do a modification. By that point, I was already living in Virginia, and Virginia attorneys told me the same thing. So limited resources. I wasn't able to bring this to court until now in Texas, where they said I'd have to fight him in the state that he's in order for them to be able to enforce anything.
I'm going to object as to non-responsive. That didn't answer my question as to when, after 2019, she came into information that Mr. Vance does not have a current child support obligation.
I don't have that information.
Ma'am, you testified a moment ago, correct, that you are aware after 2019 that Mr. Vance's current child support obligation terminated, did you not?
No, I did not. I said that I was told that I'd have to do an additional modification beyond that because we'd have to reevaluate her disability. This very judgment is because I'm arguing that it's ongoing. Had I believed that it was just supposed to have ended, I would not be sitting here spending money on an attorney. So I'm saying that that is my understanding, that it was supposed to continue, and however it might have been entered was incorrect, and that it wasn't supposed to stop.
But it did stop.
Incorrectly.
But it did stop.
Well, you're asking her to draw a legal conclusion. That's what I'm going to decide. I allow you to ask her what her understanding was. So,
Your Honor, she testified a moment ago. My understanding was that she was under the impression or had knowledge that the current child support obligation ended. And so my question to her is confirming that that obligation actually did end. It's not a conclusion of whether or not it should have ended, but did it actually terminate according to what she knows?
No, it's not. I was still receiving child support. So had I believed that it was just all going towards arrearage, that would be one thing. No, I understood it as continued child support, or should have been continued child support.
Right, but you keep saying should have been. Why?
Meaning if you're saying that it ended, then you're saying that it ended. I'm saying it shouldn't have ended. That's why I'm saying should have.
Okay. Have you received any copies of income withholding orders from Massachusetts since 2019?
They don't send that to me. Child support. Yes, child support doesn't disclose any of that information to me, not employer information, not anything.
Okay. Your Honor, at this time, I would like to ask that the court take judicial notice of the Massachusetts child support laws, which I have.
yes, I can see your screen.
Okay. This is the Massachusetts General Laws C-208, Section 28. The actual text of the Section 28 related to child support appears here in the text. It is a very long statute. It goes down several pages. I pulled a copy of this statute from the Massachusetts.gov website, so it is a copy of the actual statute as it exists today. And I would ask the court to take judicial notice of this.
Ms. Jackson, do you have any objection?
I have no objection, Judge, but
well, I don't know, Ms. Morgan Lopez, that I can take judicial notice of another jurisdiction's law, but if you're offering it, Ms. Jackson has no objection, then I will admit that as a public document.
My understanding, Your Honor, is that this court can take judicial notice of another state's law, whether or not it's a Texas law, it is a state law, and you've been provided with a copy of it.
Okay, so tell me where I look to see if you're correct about that.
Your Honor, I would have to find the authority for that. That's my knowledge at this point. I can, though, if the court would give me just a moment.
Okay. While you're doing that, but Ms. Jackson, to speed this up, it does appear to be, I'm going to admit Exhibit 6 because it seems to be a public record and a government document under that appropriate rule of evidence, so I'm going to admit it.
Your Honor, under Rule 201 of the Texas Rules of Evidence, the court may take judicial notice of a fact that is not subject to reasonable dispute because it is either 1, generally known within the trial court's jurisdiction, or number 2, can be accurately and readily determined from sources whose accuracy cannot be reasonably questioned.
Ms. Jackson, do you want to respond?
I actually don't have any objection to this law coming in because it is the basis of the brief that I've prepared.
Then let's move on. Okay, I've admitted 6. I'm not sure, Ms. Morgan, because I'll look at that, but I'm not.
Your Honor, the only thing that I wanted to point the court's attention to in that statute, sorry, I'm just toggling between screens. It starts here basically on page 3, and it says that the court may make appropriate orders for maintenance for a child who is 18 but not 21. And then again, after that, the court may make appropriate orders for maintenance, support, and education for any child who is 21 but not 23. There are some requirements for the child support, again, between 21 and 23. But as the court can see, child support does not, under the terms of this statute, continue after the age of 23 in Massachusetts. And Your Honor, with that, may I call my client?
Yes.
Thank you. Mr. Vance, I'm going to share my screen.
Yes, ma'am.
Okay. And I'm going to scroll through this document. If I'm scrolling too quickly, please do let me know. And as I'm scrolling, can you identify this document?
Yes, ma'am. Those are the documents I received from Massachusetts Department of Revenue.
Okay. And when did you receive these documents from the Massachusetts Department of Revenue?
Year 2019, I believe around March or so.
Okay. And did you maintain copies of the documents that you received from the Department of Revenue?
Yes, ma'am, I did.
Okay. And is this document that you received, did you edit or alter the document in any way?
No, ma'am, I did not.
Okay. And is this a true and accurate copy of the document as you received it?
It is.
Okay. And with that, Your Honor, I'd request to admit Respondent's Exhibit 4.
And I object, Judge, as to the hearsay all throughout this document.
Ms. Morgan Lopez, it appears to be hearsay to me.
Your Honor, in terms of well, let me go to Respondent's 5, or let me see, hold on.
So at this point, unless you're going to respond to the hearsay, Respondent's 4 is not admitted.
Yes, Your Honor, I understand. Respondent's 5, Mr. Vance, do you recognize this document that's been marked as Respondent's Exhibit 5?
Yes, ma'am, I do.
Okay. And how did you come about this document?
Yes, ma'am. I contacted DFAS, which is Defense Finance Account Services, which Department of Massachusetts sent all garnishment documents to. So I reached out to the military retirement to ask for these documents that came from Department of Revenue.
Okay. And is this a true and accurate copy of the document that you received?
Yes, it is.
And have you made any edits to this document?
I have not.
Your Honor, with that, I'd offer Respondent's Exhibit 5.
Same objection, Judge, and improper predicate.
Your Honor, in terms, this is an income withholding order. It is a public document. This is no.
Well, how do I know that? Usually a public document has a seal or a stamp.
Your Honor, with all due respect, income withholding orders in Texas do not always have those seals or stamped when they're issued by the Child Support Enforcement Agency, which is the same thing that occurs in Massachusetts.
And then you would have to get it certified, wouldn't you? I mean, why isn't this hearsay?
Your Honor, this is not a part of the official case registry in the Massachusetts case, just as income withholding orders in Texas are also not a part of the official case.
That you're making my point. It's hearsay unless you went and got it certified from the issuing agency, or it's a business record affidavit. I mean, isn't that classic hearsay?
And Your Honor, I would again request a continuance to be able to prepare this case. Ms. Jackson had 6 months to prepare.
Ms. Morgan Lopez, you have had, this is the 3rd time you guys have been here. You've had over, we started on September 22nd. It is now October the 13th.
Yes, Your Honor.
Essentially had a continuance. So you're not going to get a continuance. No, we're going forward.
Okay. May I stop my screen share?
Yes. Respondent's Exhibit 5 is not admitted.
Mr. Vance, do you have any knowledge as an individual paying child support as to whether your child support obligation is still ongoing today?
No, ma'am. To my knowledge, according to Department of Revenue, which was briefed to me, my child support obligation ended in March of 2019.
Okay. And you had an arrears judgment of about $90,000 in 2016. Is that correct?
Yes, ma'am.
And is it your understanding that you've been paying down that arrears judgment since your child support obligation ended?
That is correct. Yes, ma'am.
Okay. How old is your daughter now?
She is 25.
So you believe she would your obligation ended in 2019 because she was what age?
At the time, Your Honor, 21.
Thank you.
I have nothing further for this witness.
Ms. Jackson, do you have any cross-examination for Mr. Vance?
Yes, Judge. Mr. Vance, it's true that on April 26, 2016, you signed the order that I'm seeking to enforce today, correct?
I've signed a document through my attorney. The exact document, I'm not sure what you're referring to.
Okay, I'll pull it up for you. I'm referring to Move-ins Exhibit 2. And can you tell me if this is your signature?
I believe so, yes.
Yes, you would agree that this document is in writing.
I'm sorry, can you repeat?
And with regard to the orders that this document ordered you to do as far as child support and as far as life insurance and as far as paying the $382 for uninsured medical and as far as paying the $114 towards your $90,000 plus your $6,000 of child support urges, you would agree that you had an understanding that of what this document was telling you. There was no confusion, correct?
Not exactly. It was briefed to me by the attorney that I had at the time, and I signed the documents.
But in fact, you started making payments on April 29th, 2016, and you continued to do so, even though you missed some. You made payments because you understood what this order was asking you to do, correct?
Yes, ma'am. I've been making child support payments since 2003, and it has continued to this day. Yes.
And when's the last time you have seen Sabrina?
Objection as to relevance.
What is the relevance, Ms. Jackson?
I will reframe my question. It's true that you haven't seen Sabrina in 24 years, Mr. Vance, correct?
Objection as to relevance.
It's the same question, basically. What's the relevance, Ms. Jackson?
The relevance is, upon our last setting, Judge, my opposing counsel was asking my client about her ability or her efforts to provide Mr. Vance with the contact information that he needed to have in order to provide documents, the court orders that he is supposed to provide, an insurance, like proof of insurance, all types of information that he is supposed to provide pursuant to this order. I don't want a situation where it can be argued that Mr. Vance did not have the ability to do so. So I am trying to help the court understand that Mr. Vance, in fact, has not made any effort to see his daughter or provide the information to Ms. Green.
Well, you could ask a different question. I mean, if he walked away, if he's never seen her since she was a baby, that doesn't have anything to do with whether or not he has an ongoing obligation. That may have something to do with the kind of father he is, but that's not a custody suit.
Yes,
a custody suit.
I'll move along, Judge. Mr. Vance, have you ever provided whenever Ms. Grullon reaches out to you to ask you for your contact information, do you reply to her?
She has not reached out to me. The only time I received notification from her is in a case like this.
Okay, and so has your sister ever confirmed with you that Ms. Grullon has been reaching out to her and provided your sister with Ms. Grullon's phone number in effort for you to call Ms. Grullon?
Last time I received notification for her was in 2014 through the modification process. I have not received the address, any contact from her.
Okay. And what have you done to provide your contact information to Ms. Grullon so that she can have your contact information?
Besides responding to those issues, and the one time I spoke to her, it has not been.
Okay. What is the reason that you have not added Sabrina to your TRICARE family plan to ensure that Sabrina has medical insurance at this time?
Objection as to relevance.
Thank you, Judge.
I'm sorry, do I answer?
Yes.
Oh, yes, ma'am. At a certain age, through the TRICARE military health insurance, at a certain age, the dependents drop off.
Okay.
I have not received any additional documents that show otherwise to add Sabrina back to their military retiree TRICARE insurance.
Okay. And what is the reason that you have not been providing the life insurance with that names Sabrina as the beneficiary of the death benefit of no less than $62,500?
Yes, ma'am. I have a current life insurance, and all the children are listed on it.
And have you provided that documentation to your attorney so that she can put that into evidence today?
No, ma'am, I have not.
And what's the reason for that?
I have not provided any documentations to Lisa of known address or not being in contact with her.
Right, but you understand that I'm seeking enforcement on, among other things, child support that you haven't paid, but also your failure to maintain a life insurance policy. So if it is your testimony that you do have this life insurance policy, what is the reason that you have not provided that to the court today?
I have no answer for the court.
Okay. And then What is the reason why you did not pay Ms. Gruyon the $382 that you were ordered to pay pursuant to the April 26, 2016 order for uninsured medical expenses?
And once again, I have no contact or address of Ms. Gruyon. Last I knew, she was in Massachusetts. She lives in Virginia. So she has an ongoing moving address.
Okay. And what is your reason for not paying the $1,200 that the court ordered you to pay for Ms. Gruyon's attorney's fees?
I've never been contacted by additional attorneys or Ms. Gruyon about the attorney fees until now.
Right. But you did sign the order on April 26, 2016 that ordered you to pay all of the things we just discussed, correct?
Objection. That's a duplicate question asked and answered.
Overruled.
Did you sign the document, Mr. Vance?
Once again, I was relying on the attorney that I had in Massachusetts to brief me over the phone.
Okay. Thank you, Mr. Vance. I have no questions.
I didn't quite hear that. I'm sorry.
I didn't either.
Oh, I said thank you, Mr. Vance. I have no further questions.
Yes, ma'am.
Morgan Lopez, do you have any further questions?
I have no further questions.
Okay. Do you have any further evidence?
No, Your Honor. I rest.
You rest. Ms. Jackson, do you rest and close?
Yes, Judge, I rest and am ready to close. We'll do my closing
Ms.
argument.
Lopez, you close.
Yes, Your Honor, I'm prepared to give a closing statement.
All right, Ms. Jackson, you may proceed with closing.
Thank you, Judge. At this time, Judge, I am asking that the court find Mr. Vance in contempt for failure to number one, to follow the orders that are listed out in the April 26, 2016 order. Namely, I'm asking the court to find Mr. Vance in contempt for failure to pay $400 every Friday beginning April 29, 2016, with the exception of a few that I will go into in later detail. I am asking that the court find Mr. Vance in contempt of court for failure to pay the $96,000 in confirmed arrearages. I'm asking the court to find Mr. Vance in contempt for failure to pay the $382 for uninsured medical expenses he was previously ordered to pay. I am asking the court to find Mr. Vance in contempt for failing to maintain a life insurance policy with an unencumbered death benefit for Sabrina of no less than $62,500. I'm asking that the court find Mr. Vance in contempt for failing to pay the $1,200 in attorney's fees ordered by the Massachusetts court on April 26, 2016 as well. I'm also asking that this court find that the child support obligation is ongoing. And my basis for asking of this court is because the April 26, 2016 order clearly states that Mr. Vance is supposed to make payments every Friday until further order or judgment of this court. It is my understanding that opposing counsel's position is that child support either stopped at 21 or 23. And to that, I suggest that this order is the last order in the record of the Massachusetts trial court, meaning there's no other subsequent order that this court or the Massachusetts court can rely on to say that the obligation has ended. I would also show to the court that, yes, it is true in Massachusetts that child support does end hard stop when a child turns 23. However, there is a caveat, and I found case law, specifically the case Feinberg versus Diamond, 378 Massachusetts 131 from the Massachusetts Probate and Family Court in 1979. This is the keynote case in Massachusetts law that allows the Probate and Family Court, which is the court that this April 26 order originates from. This is the case that allows the Probate and Family Court to have the jurisdiction to provide support for a child after they turn 23. The section of the Massachusetts law that Ms. Lopez has provided to the court for judicial review, I don't disagree with it. I do agree that that is the child support statute. However, Ms. Lopez fails to point the court's attention to Chapter 215 of the Massachusetts General Law Code, section.
Your Honor, I would object at this point if she's going to go into any law that was not judicially noticed.
They certainly are, just like anybody can argue case law.
Okay.
Right? I mean, you ask me.
it's a statute that's not in front of the court at this point, and I haven't seen it. So that's my.
Well, I provided all of my argument inside of the brief that I submitted that the court requested that we.
That I got this morning, and I haven't read it because I just got served with that this morning.
Okay. May I continue, Judge?
Well, we'll get to that. Since I didn't give you a date, I said come prepared, and I'm going to read the briefs, whatever authority is in there. And then at the end of this, if you feel like you need a chance to respond to that, Ms. Morgan Lopez, I'll let you do that. Although at some point, I'm going to issue an order, and I'm not going to keep coming back repeatedly on this matter.
And so, Judge, picking up where I left off, Ms. Lopez fails to point the court's attention to Section 215, Chapter 215, Sections 3 and 6 of the Massachusetts General Law Code, which states that the probate and family court has the general power or powers to decide all matters relative to persons placed under the guardianship of another or others. This is a equity authority that is given to the probate and family court. The Feinberg case that I mentioned earlier, Judge, highlights the prime example of a child who was the child of a marriage, the parents divorced, mother was named sole managing conservator of the child, father was ordered to pay ongoing child support due to the child's being mentally retarded at the time. I would argue that these facts are extremely similar to the current case that we have here. And I believe that that is everything that the court needs to see in order to be able to make the determination that the child support obligation existed in 2016 and continues to exist today, October 13th, 2023, and will continue on until Mr. Vance or Ms. Gruyan files something else with the court requesting a different order. Thank you.
Where is this brief you refer to?
I filed it with the court. I can send it to Ms. Chambers as well, but it was accepted.
Okay, well, I did it. I see something in my court's file. You should send it directly to the court anytime you have any briefing or whatever. So please do send it directly to me.
I'll send it right now, Judge. Thank you.
All right. Anything further, Ms. Jackson?
Nothing further, Judge.
Ms. Morgan Lopez. You're muted, ma'am.
Thank you, Your Honor. I didn't realize that. May it please the court.
Yes.
As to the initial issue of whether or not this order is even enforceable by contempt, we would need to look at Texas law. And under 157.005 of the Texas Family Code, the ability to enforce child support ends either when the child becomes an adult or
well, doesn't it depend on, hold on, I'm going to stop you because I can certainly issue orders and find that child support should continue in Texas. I know that's not the issue we have here. I can issue an order that child support will continue past the child's 18th birthday or when they graduate from high school.
Yes, Your Honor, that's correct.
If there is an ongoing obligation, then I can enforce it.
Yes, Your Honor. It's our position, of course, that there's not an ongoing obligation.
No, I understand, but I think the section you were 157.005 that the court, my ability to enforce child support ends when the child becomes an adult, or that's when I stopped you. Other than I don't have the code in front of me, but I know the Texas codes.
Or at the time on which the child support obligation terminates under court order or law. And so our argument is Massachusetts law specifically states that child support ends at 23. And if child support ended at 23, this suit should have been brought earlier in the year. The child would have turned 23 in 2021, in March of 2021 specifically. And so this suit wasn't timely brought in order to the court to enforce.
You need to address, it seems to me, and I'm going to look at all of this. But in a Texas order, if I have a disabled child, I would write an order, we've all seen them, that says child support continues past the child's 18th birthday. Mm-hmm. I've got a Massachusetts order, and states are always different, that doesn't have an ending date. It says it continues. So don't you need to make an argument about how I'm supposed to interpret that? If in fact you're right, and the child support was to end when the child was 21 or 23, wouldn't this order say that, like a Texas order says, child support continues till the child is 18 or graduates from high school, whichever is later?
I think if the court has looked at the Massachusetts orders, they're all essentially Rule 11 agreements, and then you tack an order on with the judge's signature. So like a Rule 11, and then it turns into an order with a signature.
Well,
these are not orders like we see in Texas that are very specific. Actually, that's my next point. The 2016,
except that it's attached to a judge, Judge Edward Donnelly, Justice of the Probate and Family Court, signed on October 26, 2016. That the parties shall comply with the stipulation filed and dated April 26, 2016. So didn't he, it started out as a Rule 11 agreement that was adopted as an order of the court, right?
Yes, Your Honor, that's exactly my point. But my point being, it wasn't initially just like a draft of temporary orders that would, in Texas, have more information than a Rule 11 agreement. So my next argument, and I understand that the court is asking me to address the ongoing child support obligation. My next argument for this court, though, before I forget some of these points, are the fact that this 2016 order is not specific enough to be enforced. There is not enough detail under Slavin to hold my client in contempt for some of the violations.
What part? I mean, doesn't it say exactly how much and on how often?
So, Your Honor, if I may take the violations individually, please. As to violations 21 through 166, these are all of the child support non-payments between the years, I think 2016 and I don't know what year it goes through, 20.
Oh, so you're not talking about the 16 order. You want to go back to the motion for enforcement.
No, Your Honor, I'm referring to the 2016 order, but I'm telling you specifically which violations are not going to be able to be enforced because the 2016 order is not specific enough.
Okay.
So as to the language in the 2016 order related to the child support payments, not specific enough to be enforced by contempt under Slavin. And that's because we have some direction to my client to pay the payments, both child support and arrears, through the Department of Revenue. And there's no further information to my client as to how to make those payments through the Department of Revenue. There's no instruction on, as we would have in a Texas order, here is the address, here is how you make a payment, cash, cashier's check, money order. Here's the information to include with the payment. None of that information is included because essentially this is a Rule 11 that was adopted as an order. And so it is not specific enough as to how my client should be making those payments, and therefore he should not be held in contempt for those.
Okay, so let me ask you another question. When I hear a contempt motion like this, and typically it's like, and if the order to be enforced is not specific enough to be enforced by contempt, I can clarify the order. Don't I have the authority to do that?
Yes, Your Honor, and that was applied by Ms. Jackson.
Okay.
My position is just that it's not able to be enforced by contempt. As to violation 167 in the motion for enforcement, so I've just for the court's clarification, I've just addressed violations 21 through 166. In general, I do have a couple of specifics. If the court does find that the order is specific enough to be enforced, then I would suggest to the court that the court review violations number 46, 50, 54, 58, 59, and 75, because those particular violations, the payment records will indicate that there were payments received in those months. So if the court does find, again, it's specific enough, then I believe that those violations should still be wiped out. As to violation 167, which is the next violation, this is the payment of $382 in medical expenses. And the 2016 order is not specific as to how my client is to make those payments or where he is to direct those payments to. And so again, the Rule 11 agreement that was adopted as an order is not specific enough to be enforced by contempt here today. Can be clarified, of course, to the judge's point. As to violations 169 through 175, these are the life insurance violations, Your Honor, and whether or not my client provided proof of the coverage to Ms. Grillon. And as to these violations, the 2016 order is not specific as to how my client was to pay or to where he was to direct those payments. And so once again, it's not specific enough to be enforced by contempt. As to violations 176 and 177, this is the attorney's fees payments. I think it was $1,200. Again, 2016 order is not specific as to how and when my client is supposed to make those payments. But of course, again, the court can clarify those measures. Before I continue, does the court have any questions about those arguments?
No, I think I understand those arguments. Thank you.
Okay. If the court follows ex parte harass, then Ms. Jackson failed, or Ms. Grullon failed to identify Mr. Vance as the respondent for purposes of enforcement by contempt. There's a line of cases, Your Honor, out of the Dallas court, or there's a case out of the Dallas courts. This is the Harris case that essentially says sort of a quasi-criminal argument, because this is a quasi-criminal case, we need to identify the respondent as we would in a criminal setting before being able to hold him in contempt. Other than that, Your Honor, I rest.
All right. And do you have a brief as well?
No, Your Honor, we were not able to prepare a brief.
Judge, I have one more thing I would like to offer to the court.
Hold on. What is that, Ms. Jackson?
Thank you, Judge. I apologize for not making this request earlier, but I'm also requesting that the court enter an order that Mr. Vance pay the attorney's fees incurred by Ms. Grullon in this prosecution of this case. I've already had admitted into evidence in my M6 the invoices, but I do want to give the court the grand total of how much Ms. Grullon has spent with Walters Gilbreth, which is a total of $16,000.
Hold on, Ms. Jackson. The evidence was closed. I ask you, do you rest and you close? So you don't get to just come back. I thought you were going to make argument. If you're trying to get in more evidence, you've rested and closed.
I understand, Judge. I will not make any more requests for evidence. I will rely on the invoices that have already been admitted into evidence, but I do want to make the request to the court that Mr. Vance be ordered to pay the attorney's fees for Ms. Grullon.
I think you've previously made that request in earlier orders, but I can't let you, since you rested and closed, if you had additional documentation, the evidence closed.
Understood. Thank you, Judge.
Your Honor, I'm sorry, was M6 admitted?
I think during an earlier, my recollection, I'll go back and look, is during an earlier hearing it was, but if not, then it won't be considered.
Thank you, Your Honor. I don't have that notation. I either missed it.
I have that it was stipulated to.
Stipulation is not an admission into evidence. I just stipulated that I wouldn't object. That's why I'm confused, Your Honor. So yeah, I don't think it's admitted into evidence.
So if it's not in evidence, I don't remember. I'll have to get with Ms. Spicer and see if something's been admitted in evidence.
Well, Judge, may I make a motion to reopen evidence at this time?
Yes, you may.
May the court allow me to reopen evidence so that I can ensure that at the very least M6, which has been stipulated by opposing counsel, is into evidence. And if the court would allow, I would also ask the court to allow me to give the updated invoice amount for Ms. Grullon.
We would, of course, object to the reopening of the evidence, Your Honor. And I think that if we're going to do that, I would ask for a chambers conference with the court and opposing counsel.
All right, I'm willing to do a chambers conference. Ms. Chambers, can you send an invite to all three of us, and we'll go in Lopez. All right, we've come back in the courtroom after having a brief conference. All right, so I think before we left off, I was going to grant Ms. Jackson's request to reopen the record. Ms. Jackson.
Yes, Judge, I would like to offer Movement Exhibit 6, which are invoices that opposing counsel has previously stipulated to.
I have no objections, Your Honor. I would request, though, that Ms. Jackson go ahead and further testify about attorney's fees, though.
Thank you. All right. So M6 will be admitted, and you are permitted to testify as to your attorney's fees.
Thank you. I am asking on behalf of my client, Ms. Lisa Grullon, for attorney's fees in the amount of $8,491, which is the total amount that the invoices I've included for, in my M6 include. I am an attorney licensed in the state of Texas. I have been practicing since 2020. I have been under the tutelage of Brian Walters and Jake Gilbreth, and I have attended numerous CLEs. I've done extensive research on this case. I've done extensive for research, like I said, Judge. And I also believe that with the complexity of this case and the amount of information that we had to go through and dating back to 2016, I believe that the amount of time and the fees that I have incurred on this case are reasonable and necessary. And my hourly rate is $325 per hour. And that is all in my testimony.
Ms. Morgan Lopez, do you have any questions?
Only one question. I just asked Ms. Jackson and how long she's been practicing in the area of family law.
I've been practicing in the area of family law for 3 years total, and specifically in private family law for one of those years, and in DFPS child custody cases for 2 years.
No further questions, Your Honor.
All right. Thank you. I appreciate the work that everybody's put into this. I know for the parties, you anticipated coming to court one day and having this done. I'm sorry that this has taken more time. This is a very complicated enforcement, and that I have to review the briefing that's been provided and look at these orders from a different state. It's always difficult when I'm not looking at an order that's a standard Texas order. So I'm going to very carefully review the evidence that's been presented over these 3 days of testimony. I will get you all a ruling as quickly as possible. I started jury trial Monday, but I'm going to try to have this something to y'all by the middle of next week. If I can have this afternoon to work on it. Okay. I expect what I'll do is write a letter ruling, whoever is, and then I'll assign the task of drafting an appropriate order to one or the other of you. Okay.